You're listening to the Quint's podcast.
Can India turn a blind eye towards marital rape? This question is being argued in the Delhi High Court, where a two-judge bench of Justices Rajiv Sachdev and C. Harishankar are hearing a clutch of petitions challenging the constitutional validity of the exception to Section 375 of the Indian Penal Code that deals with rape. Now, while this section has undergone a series of amendments over the years, where it emphasizes on the importance of consent, this pre-colonial exception of marital rape has continued to tag along into the 21st century. Essentially, this exception allows marital right to a husband who can with legal sanction exercise his right to consensual or non-consensual sex with his wife. And this provision has been struck down in other countries like the UK, Canada and Australia. But the big question is, why does India continue to have this exception? In today's episode, we'll discuss how this exception came about, the arguments being heard in the Delhi High Court, and will striking down this exception amount to creating a new offence. Joining me today to discuss this is the Quint's legal editor, Vakasha Sachdev. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. Vakasha, welcome back to The Big Story podcast. It's always good to have you here.
Thanks so much for Himmat having me on. It's always a pleasure to try and be part of this and make sense of things.
So today what we're going to try and make sense of is this marital law exception hearings which are happening in the Delhi High Court. And before, for our listeners' benefit as well, can you help us understand the origins of this exception and what does this exception state exactly?
So basically, as everyone knows, the Indian Penal Code came into being in 1860. It's the same law has been in place from 1860 and is still in place right now. And in fact, the original draft of that was prepared in 1839 by Lord Macaulay, for the British. So it's a very old colonial era legislation. There have been attempts to try and modernize certain aspects of it. Particularly, the rape law has seen, amendments in 1983 and 2013, which were very important, where they were trying to make sure that concepts of consent, abuse of authority, all of that can sort of come into play. But at the end of the day, this is still an old legislation, and there are things about it which are there, which then the legislature would have to actively change, which they don't necessarily do, especially if it benefits things, right? Now, for instance, in 2013, there was a whole set of changes suggested to the rape laws. The Justice Verma Committee had a lot of very, very good suggestions, one of which was very clearly to remove this exception. Because what does this do? So you have Section 375 of the Indian Penal Code, which defines what is the offence of rape. It says a rape is a man is said to commit rape when he, and then now we have like it's not just sort of penile insertion, digital insertion, and even forced oral sex is falls in the definition of rape. Now the thing is, it says a man is said to commit rape if he does this to a woman, and then there's a set of conditions specified. It says that if the following circumstances are met, so then there's firstly against her will, secondly without her consent. I know that it also has the stuff for statutory rape and where a woman, is unconscious and, or inebriated and, can't give consent. So all of these things, that's how the definition is structured. And then you have two exceptions to it. Now, the first exception is one which is there for medical practices and things. That's something which was added recently, where you had, because you are now having a thing saying that, okay, if you insert an object into a woman's body, this would also count as rape. You had to then also obviously say that, okay, when that's for a medical procedure or intervention, then, that doesn't fall within the definition of rape. The second exception is something which has been around since the very origins of the IPC, which is this marital rape exception. Now, what that says is that sexual intercourse or sexual acts by a man with his wife is not rape. Now, there's also an age thing there, which earlier it used to, over the years, that's had to be changed because initially it was like a man with his wife, not, where the wife is not 10, is not lower than 10 years of age because, patriarchy.
Yeah.
That's over the years been changed. Now it stands at 18 years, which is the general age of consent. Even if you're married, if the woman is under the age of 18, then this marital rape exception doesn't apply. That was something which the Supreme Court had to do, by the way, in 2018 to make that happen. So 2017 to make that happen. But just sort of coming back to the marital rape exception itself, it says this is not rape. Now, this is because of a very old concept of the way marriage and sex works in marriages,
Mm-hmm.
which is comes from English common law, like from the ancient past. You have like what's called, this concept of coverture, which is that when a woman gets married, she's essentially signed away all her rights of agency and consent to sexual relations to her husband. And in fact, in England, it was much more than that, right? Because
Mm-hmm.
essentially, a woman was treated as property of her husband, or she couldn't enter into contracts, she couldn't own property or anything, in her own name. Everything had to be through the husband.
Mm-hmm.
Now, as a result of that, you had this concept of in a marriage, a woman will always therefore be consenting to whatever her husband says when it comes to sex. So therefore, there can never be rape within a marriage. That's how it came about in English common law. And was originally drafted by first you see it written in this guy Lord Hale from like the 18th century, in the
Wow.
1700s, writing this. This man was saying this stuff,
Mm-hmm.
and that became part of English common law and remained there. Till finally, in fact, in 1991, the English courts were like, you know what, this doesn't work. And it had even actually, there had been changes to the way it operated and all of that, but they said, this cannot work. It creates an immunity for husbands to this stuff. It cannot work within the context of the way we look at modern relationships, the equation between a man and woman. Just because a woman's married doesn't mean she loses all those rights. So therefore, this exception has to go. And this immunity has to go. That was how it was done away with in 1991 in the UK. And then in India, of course, this remains there, even though, it's such an antiquated concept. And if you look at, in fact, the original draft which Macaulay wrote of the IPC, it has notes about this. And he clearly says there that this is an exception in favor of the conjugal rights of the husband.
Mm-hmm.
So it's not that this is, there's, in like the whole concept here excludes a woman's agency and her right to give consent. So that's the origins of this. And, so you can see that it's coming from an English common law concept, which sure may have been, what it was at the time. But these are the kind of things which have to change over the years. And our legislature, even though that's been put before them, has had the opportunity to do this, has not done so. So, that's the sort of background where we're at and where we've reached.
Okay. Now, I mentioned at the start of this episode as well in my intro that this exception has been struck down in other countries, especially the UK, from where like it came about in India as well. So why has it not been struck down in India yet? Like, what is the government stand on this? Like, why do we still have this very, very uh, complicated work? Yeah.
It's a real mess on
Yeah.
this, because the thing is, I mean, we're one of only 32 countries, I think,
Mhm.
currently in the world which still retains this.
Wow.
And the thing is that, it is at the end of the day, sometimes it's now become a joke to say everything is the patriarchy, right? But that's literally what this is, because there's a patriarchal idea that in marriage, a woman, that the whole point of marriage is for a man to have sex with his wife, and he has rights to do it, and this is a right, and he has exclusive possession over the woman. This is something and this isn't just a social concept. This has permeated issues of law as well. And this was something which was very, I think, interestingly brought up by Rebecca John, who's the senior advocate, who's an amicus curiae and, friend of the court, an expert who the court has asked to advise at the Delhi High Court on this. And she has brought up she was able to show how, there's a whole set of things in the 2018, the Supreme Court struck down the provision on adultery in the Indian Constitution. And there's a lot of very interesting things where Justice D.Y. Chandrachud talked about how the law can be used to preserve the status quo, can be used to entrench patriarchal norms and oppression of and subordination of women. That's what this is all about. And that's something which, at the end of the day, that's what the male legislators in particular, or conservative legislators, want. And you see this, in India, we had the Law Commission had been asked to look at this in the past, and they came back saying, oh, you know what, having this, removing the exception would be a threat to the institution of marriage. And this is the constant line. Even in 2013, when it was rejected, because the Verma committee had said it should be removed, in the aftermath of the Nirbhaya incident, they were proposing a whole set of reforms on the law on rape, and they said, you know what, this exception doesn't work anymore, it should go. In Parliament, basically, it was not done because it was viewed that this would be a threat to the way marriage functions. Now, I mean, that gives you a slightly horrifying idea of the way marriage is a concept is understood in India even today. And if you look at what the central government has filed an affidavit in the Delhi High Court, which is hearing this challenge, and they are saying, yeah, our law commission also said this, and we think that it's we can't just take this up without having a broader consultation. We have to take every stakeholder's opinion, which basically means what the men want to do with this, and only then can something be done about this nonsense. So essentially, it's a thing about preserving the status quo, preserving a sexist patriarchal status quo, and it's about ensuring that certain gender roles within a marriage are protected, and the rights of a husband are protected. And we saw this again, like, we've seen repeated comments by one of the High Court judges, Justice Hari Shankar, where he keeps talking about a right to sex within a marriage. He keeps trying to amend it to say, oh, I'm only talking about an expectation. But he still believes that there is a difference between, marriage and non-marriage, where the parties to a marriage have a right to expect sex. And that's sort of what this is really all about. I think, it's a protection of a husband's expectation that he has a right to sex, which somehow is still part of the discourse in India.
Yeah, somehow this law has just, this exception has just tugged along to the 21st century as well. Now, I want to move to the clutch of petitions which are being heard in the
Mhm.
Delhi High Court. Like, how did we arrive at
Yeah.
this point, and what are they testing in court exactly? Like, what are the arguments?
So in 2013, you had the RIT Foundation. It works on gender and social justice issues. They'd filed this
Hmm.
petition. It's been joined in by the All India Democratic Women's Association, which has representations made to it by women who'd faced marital rape.
Hmm.
And then there's even one woman who has faced it. She's also filed this petition, and then there's obviously a bunch of other interveners. That's where this whole thing began, because the thing is, essentially, for a woman, there is no, even if you're facing rape by your husband, you can try to file certain other kind of things. You can even try and file for divorce on this basis. Now
Hmm.
many high courts have said, but there's a difference, right, between having a civil remedy and a criminal remedy. And the whole problem is that, like a criminal offense, when it's being committed,
Hmm.
so the idea was to try and get the courts to understand that there is a problem here, that women don't have that option. It is unconstitutional for this exception to exist. It violates the two key constitutional grounds which it violates,
Hmm.
and therefore it needs to go. Now, what are the two constitutional grounds? There are uh, two articles of the Constitution which have been looked at in your fundamental rights. Article 14, people tend to look at it as the right to equality, but it's actually a bit more than that. The wording of Article 14 talks about the right to equal treatment by the law. And what they're saying is that, look, you are creating an unequal treatment of married women and unmarried women. That, when that by solely by virtue of getting married, a woman now loses the right to say that, to be able to file a case against a man who is forcing her to have sex just because she is married to this man.
Hmm.
So it's the same offense, it's the same issue, but you're saying just because marriage is there, it changes. So that's one ground. And there's more nuance to it as well, which, the amicus curiae has also argued, and Rebecca John has been able to argue as well. But that's broadly the broad idea, is that you're creating a distinction for which there is no real basis. That's the first thing. And the second is a violation of Article 21, which is your right to life. And over the years, the Supreme Court has built in this understanding that the right to life is not just sheer existence or survival. It's a lot of other things which come in: your dignity, your privacy,
Hmm.
your autonomy, which includes, your right to make sexual choices, which include the right to say yes and no.
Hmm.
So there's a violation of that here, because you're saying that a woman doesn't get to say that these married women don't get to say no to their husband, even if they want to, which is a clear violation of your right to dignity. It's a clear. It creates it's something which creates harm to you. It's causing a problem to your life, and the way you want to live it. So, it's a it's a very obvious, it's a very simple argument to understand. I think,
Hmm.
even if you don't understand, even if you're not really into the law, it's a very clear and simple argument that this is what it does. There is no real basis for this, and that's sort of where it should end. You'd think logically it's so clear that yes, there is an unreasonable classification between married and unmarried women, and there's a clear violation of a married woman's right to choice and dignity.
Hmm.
um that's sort of what they are arguing.
Okay. So, can you also speak on the arguments made by like senior advocate Rebecca John, who has been on the show before as well, and who's also now like a
Mhm.
amicus curiae for the court, for the Delhi High Court. Like, you've also recently written an article uh, on what she has said exactly, making her submissions
Yeah,
to the court.
yeah,
So, can you
yeah.
speak on that
Yeah, so what's important to remember is that as we've told you what the petitioners have argued of why it's unconstitutional. Then in response to that, now you don't exactly have this is not exactly an adversarial thing, right? It's not as though you got A versus B coming and fighting and saying you don't openly obviously have anyone coming and say no, but a man should have a right to rape his wife, right? That's obviously not going to happen. So the arguments against it are slightly different. So we've seen arguments by a bunch of men's rights groups, which I know one's supposed to try and keep an open times, but I mean, my God, like men's rights groups. Okay, assuming there's some seriousness to have to be given to what they have to say, their argument is that, oh, there is a legitimate ground for there to be a difference in the way the law treats it, and there's a high risk of abuse of this provision if it's allowed in. Because within a marriage people live together, so it's easy to be able to try and make up a claim about false rape. That's all their argument is. The Delhi government came in with a couple of other points, which were that, okay, women already have other remedies, so you don't need rape, as in you don't need to be able to say, oh, I can go and file a case for rape, because you can file for divorce, you can file a case of cruelty under section 498A of the Indian Penal Code, you can file for grievous hurt, all of these other things that you could do. So the Domestic Violence Act is also there, which, by the way, just to clarify, because a lot of people keep throwing around the Domestic Violence Act as a criminal law. It's not. It actually is only for civil remedies. The only criminal remedies if a husband ignores it. So, for instance, if the court says, oh, there's a protection order for this woman, you're not supposed to touch her, you're not supposed to harm her after she's made certain complaints. And then he does that, then there are criminal consequences for violation of the court order, not for the actual act itself, in a sense.
Okay.
But yeah, so their argument is, oh, there are all these other remedies, so there's no real, so it's not as though the exception, the marital rape exception per se is treating women differently. It's just saying that they can't use this particular remedy, but they have other remedies for the same thing. So you know what, there's no big deal. And the other thing which the Delhi government raised, and one of the lawyers for these men's rights groups had raised, is this also is the creation that if you remove this exception, you're creating a new criminal offense, which the courts cannot do. That is something only the legislature has the power to do. The judiciary, when they have the power of judicial review and to strike down things as being unconstitutional, you can't create a new criminal offense, because that is, the idea that criminal law has to be it has to be interpreted strictly. It's supposed to be done very carefully. Blah blah blah. There's a whole set of things. Now, that is the thing, is that this has been argued it's not been argued well, whether by these people or even by one of the judges on the bench, Justice C. Harishankar, keeps raising this objection. It's not been argued well in the sense that, there is a point here, and it's something which the court has to address. The High Court cannot possibly strike this down if it can't address this question. The problem is that this question is actually very easy to address. Yes, it's a question to be addressed, but the answer is also quite clear.
So one of the justices on the bench was in support of this, as you said, but was that the general consensus, or did the court have an answer for why this may not work?
So, in my opinion, there is a split between the two judges. I mean, this was actually this was brought up in the court because I'd written an article about how it looks like there's a split between the judges, and one of the judges made a comment about how people in general is already talking about this stuff, and they made a bit of a joke about it. But so I think it was slightly subtly dragged there. But the thing is, there are two judges on this bench, Justice Rajiv Shakhter and Justice C. Harishankar. Now, look, we can't say at this point that we know who is going to rule which way or not. That's not the case. But there is a slight difference in the approach. Like, Justice Shakhter's thing kind of seems to accept that the key issue about looking at when you're trying to decide what is the offense of rape and how its exceptions have to be looked at is about consent of the woman. That is the key issue. Everything has to be looked at within that lens. That's that was how the initial amicus Rajshekhar Rao, who was arguing on constitutional law issues, was also kind of, his arguments were predicated on this idea. And Justice Shakhter seemed to be in consonance with that from the questions he asked, the comments he made. He made a comment, for instance, at one point, that I don't know why we keep talking about this on eggshells. There is no question of the relationship between parties allowing it to be legal and not legal. So that's the kind of comments and the questions he was asking. On the other hand, Justice Hari Shankar keeps saying, I don't think that you're only looking at these arguments from the point of view of the woman. Consent of the woman is not the only issue in rape. There's a whole question of an act and everything, etc., etc. It's, and he talks about how that, look, you are assuming that there is no basis to say that a married woman and a non-married woman should be treated differently, but there is a difference between marital relationships and non-marital relationships because of the expectation of sex and conjugal rights within a marriage. There is a difference, and therefore if the legislature has not changed this and not got rid of this exception because they want to treat these things differently, we can't it's not obviously wrong or so obviously wrong that the court has to strike it down. The thing is, so what this could mean, and as I said, and I make this very clear, this is not that this will happen, but the way that what this line of reasoning and this approach means is that while Justice Sachdev will be looking at, okay, is there is the issue of rape a matter of consent? Is a woman not being given consent? Therefore, okay, should it be struck down? Whereas with Justice Hari Shankar, the approach seems to be that, okay, maybe even these issues are there, that this is preventing a woman, this is saying that a woman who doesn't consent will not have this option. But, you know what, our hands are tied because that's not something which we can go into. It's not within our scope of what we can manage to do because that's not what the legal issue is. And that's sort of where, that's where this issue is coming. And that's why this issue of creation of a new offense becomes very important again, because this only works, this sort of legal technical objection only works if you say that, okay, we are creating an entirely new offense by removing the marital rape exception. And I think that's been answered very well in Rebecca John's arguments. And in particular, she's explained this, I think, really, really well. She began by, what we talked about, the way this whole thing began with Macaulay and Hale and the English law of coverture. She took the court first through that. Then she's gone into how, the way the offense is structured. If a man does XYZ to a woman and these conditions and consent are fulfilled, then it is rape. So she's broken down what the offense is. There are descriptive acts, there are circumstances involving consent. Therefore, she's explained that consent is crucial. That is what the crux of the offense is. Yes, it's looking at it from the point of view of the woman, but this is a gendered offense. It is meant, the only victims here can be women. It cannot be a man who is a victim of rape as it's defined. So therefore, you have to look at those issues. She then, I thought, and this was an absolutely brilliant argument, was she looked at what is there in what the Supreme Court has previously held in the case which we mentioned earlier about the striking down of adultery. Now, what's important about that is that in that, Justice D.Y. Chandrachud made a number of very, very key observations about what marriage, about how, a marriage cannot have a situation today, and in terms of the Constitution, cannot allow for an unequal treatment of the husband and the wife. If you're going to give, essentially, if you're saying that the husband has all these rights to agency and consent and decision making, the woman can't be deprived of those. And if you're going to have a law or a legal provision which allows that subordination, which allows that to happen, then that law cannot possibly be constitutional. And that was why they struck down adultery, because that was saying that, the husband gets to decide who the woman can have sex with. Because, it wasn't even just that a husband can complain if his wife is having sex with a man. It was that he can file a criminal case against that man unless the husband had given consent. And this was in the provision itself, right? So essentially this whole, that legal provision in the IPC was all about subordination of the woman and a very antiquated notion of marriage, where the husband had possession of the wife. And therefore it had to go. In the same way, Rebecca John was able to argue, Section 375, this exception to this marital rape exception, does exactly the same thing. It's saying that a woman doesn't have this right to consent. She doesn't have a right to agency. And, and the thing is, the courts have to look at the effects of something. They can't just look at, okay, what was the objective of the legislature? What do the words say? They have to look at the consequences. That's something the Supreme Court has held in the 9-judge right to privacy judgment, the Puttaswamy case. It was said in the Navtej Johar case, the one which decriminalized Section 377 of the IPC on homosexual acts. So, all of this stuff, the Supreme Court has been very clear that you have to look at the effects, and you can't have a law which essentially is creating a subordination of women. And on that basis, it's very difficult to see how, in any way, this exception can remain. unless, of course, we come back to that issue of creation of a new offense. But again, as Rebecca John's shown very well, there are two reasons to very clearly say that isn't the case. One is that when the Supreme Court read down the marital rape exception in 2017 to remove it for minor girls, it had already clarified that this doesn't create a new offense. It had already said it, and it went to the reason that, look, we're making something in consonance with the rest of the law with constitutional obligations that is not creating a new offense. And the other thing she pointed to was when the UK House of Lords, which back in the day the House of Lords had a judicial sort of section which was the equivalent of, say, our Supreme Court. So in 1991, when the House of Lords struck that down in England, they very clearly, in fact, said this is not creation of a new offense. This is merely removal of an immunity which has come about because it is offensive and it is not, and it is, it cannot possibly work within the framework of liberty, and therefore we have to get rid of it now that it's been brought to our notice. And John was able to point again to more Supreme Court judges which have said that it is the duty of the courts to intervene once they can see that there is a law like this which is clearly a violation of the fundamental rights of a group of people. And that's what's happening here for married women. So this whole thing of a creation of a new offense is a manufactured idea which has been addressed by courts in India and elsewhere already. And it is just the removal of an immunity for a certain class of people. And therefore, once that argument is dealt with, I think everything else just sort of slides away, which is where we're at really. And I think which is also why there's this desperate attempt to keep bringing up this issue of creation of a new offense, because there is no other argument which justifies the marital rape exception.
Okay. Well, Vakasha, thank you so much for summing it up for us as well, and also informing us where we are at with this clutch of petitions as well. And that is also the end of the episode. But listeners, Vakasha has written a lot of articles on this, which explain ins and out of the entire case and what's actually going on in the court. So do check them out, and a link of those articles will be in our show notes as well. If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.